13th, I also filed, of course, a motion for leave to allow me to supplement the Second Amendment verified complaint pursuant to OCGA 911 15D. I think as a first matter of business, I think that the court will have to, before we get into the crux of the case, that the court would have to make a decision on the leave. That the court would have to make a ruling and basically allow for me to allow for leave in order to do the supplement to the Second Amendment verified complaint. I think that's the first.
Let me back you up. The plaintiff's emergency motion was filed August 13th. The supplement was filed August 13th as well. Obviously, the supplement is not properly before me. But what the order in Rule 9 side outlined was your plaintiff's emergency motion for temporary restraining order and emergency of August 15, 2026, which relates back to your original second verified complaint, not to this supplement to your second verified.
Well, what I'm saying is that the parties have already resolved, so to speak, through a consent agreement or consent judgment, the issue as related concerning resolution R26/1955. Right. And what I just wanted to make sure that the record is clear, for clarity, that the court recognizes and understands that because there's a pending motion for leave as it relates to supplementing the Second Amendment verified complaint, I think that has to be dealt with first. The court has to make a ruling. Okay, and then we go into that. And the reason I bring that up is because counsel indicated that this was a new action, and then the court said that we would deal with that today. And so my argument is that it's not a new action. This is a supplement to what's already was pending, and so that's why I brought that up. As the court understands, there were a lot of twists and turns in this case. We started off with a resolution back on July the 17th, 2026, whereby the city adopted a resolution as well as some charges charging the mayor with various allegations, saying that he violated the charter in his position as an elected official. Since then, there have been council has gotten together, and they basically have set a hearing. And I think initially the hearing was for August the 15th, but that was moved because the council failed to give the mayor any type of notice. And so the 10-day notice that was required by the charter, they failed to abide by the charter. And so they, on their own, went back in session and believing, and they set the hearing again for August the 22nd, which will be this Saturday at 9 o'clock. And so this motion and these motions deal with those issues because we believe that one of the councilwomen, Lakeisha Gant, is biased. She has prejudged this case, and that is based on not just me saying it, it's based on the text messages that she has written and sent to the mayor's grandmother. It's also based on text messages that she sent to a gentleman by the name of Bruce Smith, and it's also based on Facebook comments prior to this hearing, also prior to the hearing on the 17th, whereby she has basically made some statements that we believe will cause her to be biased, and that we believe that she has already made a decision in this case. So that's why we're here today. We're going to be asking the court at the end to enjoin the city from allowing Lakeisha Gant from partaking in the decision making in terms of at the hearing on August the 22nd. She is an arbiter, and so our position is that the charter as written does not allow for any type of mechanism when you have a person or a council person who is obviously biased and who has prejudged. I will tell the court that I filed on, I believe it was Sunday, or I believe it was Sunday, and the court should have that, but I filed my letter to Councilwoman Gann asking her to recuse herself. I sent the letter to her last Friday, gave her until Saturday, until noon to determine whether she's going to voluntarily recuse herself. She has not answered my letter. And to date, she has refused to recuse herself. As a matter of fact, the last time we were in court, counsel for the city indicated that we did not ask her to recuse herself, and she may very well do so. But I'm not of the faith that that's going to happen. So I believe that this case is ripe for determination by this court. This court has the jurisdiction to be able to make sure that equity is done fairly, and that based on the cases that I have already cited, but I will cite later on when I do my closing, we believe that this is proper for the court to enjoin the city from moving forward with allowing Ms. Gann to act as an arbiter in this case. Now, the court can do several things. The court can enjoin and stay the hearing for Saturday until the city implements some type of mechanism to deal with a situation when you have what I believe to be a biased council person who's going to be presiding over the hearing. So you can stay it, or you can enjoin, or the court can allow to do a stay and allow the parties to partake in brief and limited discovery. The court has various options in this case, and I'll come back in my closing and talk about what I believe that the court should do in this case in an appropriate mechanism. My first witness, I don't know, Mr.
Hold on, let me get Mr. Washington to do this.
Okay.
Mr. Washington? Just turn it off.
Good morning, Your Honor. We have filed a response, which I'll walk the court through, but the first thing is this, Your Honor. You can't go to court for a divorce and then come out and be guilty of murder. And that's how extreme these two things are. A TRO was filed. A consent judgment was issued, or is going to issue, but the parties read everything into the record. At that point, the case was affirmatively closed, right? Unless there is leave to file something, then there's nothing that's in front of the court. And even as we discussed the last time, Your Honor, the Rule 9 side says that we're here for the pleadings that he's filed, but it ends there because there has to be notice about what we're arguing. However, we have filed, immediately when they filed their answer, we filed a response. And we filed a supplemental response today that I will walk the court through.
You said today?
Yes,
At what time?
this morning, about a couple hours ago.
And I have to see
Yeah.
Because I was in there for 8:32 and I didn't see it. So let me have it printed. So you go ahead and put it on record now.
Okay.
And we knew more than all the information that, and we haven't already heard.
Okay. You know, and then, because I don't know a couple of things. One is that if a motion for leave is filed pursuant to 9/11/15D, it has to be granted. If nothing is granted, which is the case today, there's nothing before the court. But also, the subject matter that they're speaking of is far afield from what we were originally here for. What we were originally here for was a TRO about the mayor's authority, right? That matter was handled. And then they filed a set of supplemental pleadings, but it's as if they're trying to, or attempting to use this one case number that they have to morph and to continue to have this court police a proceeding that the charter gives them the ability to have, which is this Saturday. Right? So that's the macro point. I want to walk through the specifics of this. On July 17th, the council adopted that resolution regulating the certain administrative procedures. They filed their verified complaint on July 20th. Plaintiff subsequently filed an amended pleadings, which challenges the second resolution, which is in 1955. The court consolidated and heard everything, and then the motion dismissed, and the injunctive relief was set for the hearing. Right. On August 5th, we adopted another resolution initiating proceedings and what would happen under those proceedings. Plaintiff was served with this matter. The plaintiff was also at the hearing when this happened, and that was on August 10th. So, Your Honor, to be clear, there are two letters. He was sent a letter in July saying that he needed to respond by July 31st. The city got no formal response from him. That was what he was given, right? Then he was sent a second letter, which was dated August 5th for a hearing on the 22nd, right? And he was served with that on the 10th. The August 22nd hearing has not occurred. No evidence has been admitted. No witnesses testified. No recusal request has been denied. No finding has been entered. No vote has been cast. And no removal has occurred. Now, when he filed this on the 13th, he hopes that this would expand the proceedings, but it can't because the Rule 9 side doesn't address it. But then the other thing is this: the court should deny the leave under 91115D, because 91115D provides that upon motion of a party of the court, upon reasonable notice in such terms that are just, permit the party to serve a supplemental pleading setting for transactions, occurrences, or events that have happened since the date of the pleading sought to be supplemented. Since the date of the pleading sought to be supplemented. So, if he is supplementing his original pleading, the only thing that his original pleading talked about was what duties the mayor did not have, right? So that's any supplementing of the pleading that would be relevant pursuant to 91115D would be that. This is not. Councilman Gant is not. Separately from all of that, the statutory text also imposes a limitation. A supplemental pleading addresses transactions, occurrences, or events that have happened after the pleading is supplemented. Here, the verified pleading, as I was saying earlier, seeks to supplement the second amended verified complaint on July 24th, 26. Events that occurred before July 24th are not proper subjects of supplemental pleading under subsection D, right? Because when you look at the timing of what he is specifically speaking about, the timing even for what he admits in his pleading that he was speaking about occurred well enough in advance of the hearing that he could have then decided to bring those, but he chose not to. Plaintiff's proposed filing, therefore, improperly combines pre-existing facts that should have been included in an amended pleading. If at all, later events did not establish a completed constitutional violation and requested emergency relief that substantially altered the issues already scheduled for a hearing. Right? One of the cases that he talks about is the Tyson versus failed properties in 1996 for the proposition that a distinction between an amendment and a supplement depends on timing. That's misplaced. Tyson concerned the enforceability of a real estate option, and the trial court's grant of a partial summary judgment. Critically, Tyson does not cite, construe, or apply 91115 at all, much less the subsection D. The motion is untimely and will also prejudice the city because we're ready to have the hearing on the 22nd. Everybody's been noticed, and it can't be an emergency something that could have been dealt with through prior pleadings that he has done. But what I also think is important is that plaintiffs on Exhibit F demonstrates that the attorneys or representatives possess at least some of those communications underlying the proposed supplement by August 3rd. Exhibit F recounts Councilmember Gant receiving calls from a news station and comments between her and Vivian Thomas. Thus, plaintiffs own evidence, the material that was known no later than August 3rd, but was known before. They chose to file on the 13th, and they asked for no adequate explanation for that. The just terms on the 91115D authorize the court to deny. The other thing is that they're asking for some level of declaratory relief, and as we've already discussed, Your Honor, under 942A, declaratory relief must address a concrete uncertainty affecting the plaintiff's own future conduct. It is not a vehicle for obtaining an advisory ruling concerning how another party may act in the future. That's Cobb County versus Floam, Your Honor, which is 319 Georgia 89. The Supreme Court explained that declaratory relief is unavailable where a declaration would not directly Schools, 307 Georgia 877. The Supreme Court has held that courts lack jurisdiction over claims presenting no justiciable controversy, emphasizing that a declaratory judgment must have an immediate effect on the party's conduct and cannot merely eliminate abstract uncertainty. But also, plaintiff's proposed counts are contingent on a series of events. It's contingent on Councilwoman Gant, what she may do in a proceeding that has not happened, that would ultimately lead to a result that would negatively impact him. That if then chain is too far. Also, the most important thing to note, Your Honor, is that there is a municipal process that they're not participating in, right? We have a letter that was sent to them saying they could respond by July 31st. There's also the tribunal that the council is going to sit in where these matters can be brought. They have not, even by the own admission of council, been brought to the tribunal for them to make a decision. So this, in essence, will be leapfrogging the tribunal who has ultimate decision. The constitutionality and the due process argument Mr. Ash will speak to, but I want to make sure that I speak to a couple more cases. One, City of Ludowici versus Stapleton, which was the 258 Georgia 868. Right? What's very specific in this is that although it requires judicial qualification when a council member previously participated in preliminary matters, that's not the holding of Ludowici. Ludowici addressed a removal process that lacked basic structural protections, including adequate notice, a defined hearing process, a standard of proof, defense rights, subpoena authority, and an impartial decision-making structure. The case does not establish a categorical rule that a council member's prior involvement in municipal affairs automatically creates unconstitutional bias. Here, and I think it's important to note, the way in which this happens is very similar to what happens in judicial matters or other administrative matters. Them sitting as the city council, they have a charter given authority to make a determination about whether to further investigate something. That's what they did. So sitting in their capacity, that means they're going to get information to then determine whether or not there needs to be some level of investigation. From the point in time in which they have determined there needs to be an investigation, they can then have that investigated to have that information brought back to them. That is the process that we're in now. So they're going to get information, and they could have gotten information from Mr. Kenner and his client prior to making their decision, but they chose not to. When you look at the first letter, the first statement of charging letter that was sent to them, that letter said, if you have anything you want to let us know, you can respond to this in writing, et cetera, which, let me go ahead and just quote that, Your Honor, just so you can see that it's attached. But it says, in the letter that's 21 pages, that was, there's my exhibit G1 on what I submitted, the date was July 17th. It says that scheduling rights and investigations, right? That such investigation is supposed to last approximately 30 to 45 days. Once council has reviewed the final report, they will decide if further action is warranted. And response period. Mayor Williams may submit a written response to these allegations within 10 business days of receipt of this notice, subject to reasonable extension for good cause shown, etc. And he can have right to counsel. None of that was done. When he received the letter that they were talking about, the August letter, that August letter contained less charges than the July letter, and they still had the right to respond because it said that this does not supersede, except that it may amend the charges that they received. They still chose not to do that. The reason why I'm saying that, Your Honor, is because they can't pick the form that they want to have this in, which is what they're attempting to use this court for, because they simply disagree with the form choice that the state charter of Georgia gives it. I also want to make sure that I know that one of the cases that has had a bunch of discussion was the Clare versus Matthews. That Clare versus Matthews case, I want to make sure I spend some time on it and address a situation in which the governing procedures did not provide an adequate mechanism for challenging the impartiality of a tribunal member at the relevant stage. The court held that equitable relief should be considered because the petitioner lacked a complete and adequate remedy for presenting the biased objections. Clary did not hold that an allegation of prejudgment automatically establishes bias. It did not hold that a court must disqualify municipal decision-making before a recusal request is submitted, nor did it hold that every allegation concerning a decision-maker's prior statements requires a stay of an authorized proceeding. The distinction is material. Here, plaintiff may present a written recusal request supported by evidence, obtain a ruling, preserve the issue, and seek review if an adverse decision occurs. The procedural defect central to clarity, the absence of a mechanism for presenting the objections, is not present here. But here I can already tell you is the problem. There were a set of rules that were set out in the initiation of removal proceedings that said what steps needed to be taken and how they could be taken, and the information that he received as early as August 10th. And what it said was that each party had the right to, the exchange of witness lists and investigative subpoenas and recusal and ex parte communications and preservation of evidence. All of that was in the letter that they received, and they're not going by that process that the city council has the right to be able to establish. And that's where I think the problem comes in, Your Honor. But I also want to make sure that we go through Withrow, Del Cook, Timber, and Pence about their per se bias. And I'll let Mr. Ash go through that. But also, you have to note that even in looking at their exhibits, and I don't think that we should even have to get all the way to Councilwoman Gantt, who, even though she's here, would take a stand. Plaintiff's exhibits do not establish an irrevocably closed mind. Plaintiff relies on isolated phrases, and those phrases cannot be evaluated in isolation. Context matter, and the data of the communication, the complete communication thread, the identity of the participants, etc., all of that matters. Whether the speaker later qualified the statement, and whether the communication was complete, authenticated, or unaltered. Plaintiff's own pleading identifies statements pointing in the opposite direction, including statements the investigators should be allowed to work, that everyone was made to see, and that the council was not attempting to set up the mayor, and the speaker could not comment on pending allegations. Those competing statements do not establish an irrevocably closed mind as a matter of law. Plaintiff also asserts that discovery is necessary to determine authentication, authorship, completeness, chronology, editing, deletion, metadata, and context. That assertion confirms why emergency disqualification cannot be ordered on the present record. Plaintiff cannot simultaneously argue about fragmentary excerpts and conclusively establish constitutional bias, and that discovery is necessary to determine what the excerpts are and what they mean. Also, the city of Macon versus Anderson does not establish a present basis for prohibition. Plaintiff's reliance on OCGA 9640 and City of Macon versus Anderson is incomplete. City of Macon recognized that the city council conducting a removal proceeding may function as an inferior adjudicatory for purposes of an appropriate extraordinary writ, but the decision did not hold that a court must halt a municipal proceeding because a party predicts that the tribunal may commit a procedural error. The writ was reversed because the council possessed the authority to try the charges, which is what Stockbridge does, and that's the holding that the city asserts. The city council indisputably possesses subject matter authority under the charter. Plaintiff's allegations that concern the anticipated matter in which jurisdiction may be exercised. A predicted procedural error within the conceded jurisdiction is not the same as an absence or an excess of subject matter jurisdiction. Prohibition is an extraordinary remedy. It is not a substitute for an ordinary challenge to a future evidentiary ruling, recusal decision, or a final municipal determination. The next case that I want to make sure that we discuss is the City of Cumming versus Flowers. It supports the review through our described process. The Supreme Court has held in the City of Cumming versus Flowers, that's 300 Georgia 820, that a local quasi-judicial decision was subject to the prescribed Superior Court review mechanism, and the mandamus and injunction were unavailable where an adequate remedy existed. The city does not contend that Flowers creates a categorical exhaustion rule for every municipal proceeding. It holds a narrower and more directly relevant holding, where municipal municipal body acts in a quasi-judicial capacity, and the law provides a mechanism for review on an actual record, a party ordinarily may not bypass the process through emergency equitable relief. Here, the charter provides a hearing process and a review following final decision. At the end of the day, if they truly want to appeal, they have the right, as we've discussed earlier, to come back to this court where we currently are after the proceeding has occurred to be able to point out if they think there are errors. Speaking on the injunctive relief, they have not shown, and they can't establish in this, that they have a likelihood of success because the proposed claims they're all talking about depend on future events, right? So they would be asking you to enjoin something that's going to happen in the future, which is the hearing, which is far afield from anything that was initially before this court. They've not shown any irreparable injury. Mr. Ash will speak on the due process and the guarantees of a fair hearing, but I want to make sure that I point to Lew versus Edie, which is 297 Georgia 321. The Supreme Court emphasized that interlocutory relief requires a substantial threat of irreparable injury, not a speculative claim of future events. Plaintiff's alleged injury depends precisely on a claim. One thing that I want to note is that the balance of harms favors the city. The city is spending an inordinate amount of time trying to get ready for a hearing that they have noticed and have the planning and the procedures ready for, and to adjudicate these municipal charges, and to disrupt the charter authorized process to require the court to supervise a hearing before it occurs can potentially return the city property and administrative access before the hearing, but the proceeding under the safeguards imposes no cognizable inequity. Plaintiff receives notice, counsel, presentation of evidence, cross-examination, argument, a preserved record, recusal procedure, and judicial review. The balance of harms favors allowing the process to proceed. The reason why I'm going through these 4 points, so these 4 points are the 4 points necessary to get over the threshold to even consider the injunctive relief that they're requesting. The 4th point is the public interest allows the charter, favors allowing the charter process to operate. The public has an interest in both the adjudication and timely municipal accountability. The adopted procedures preserve both processes. And the other thing is that the plaintiff attempts to use the new bias allegation to renew a request before the court that has been closed out. And so even when we go and look what could happen, and that's why we're not trying to over-litigate this case, Your Honor, what could happen is that there is a motion to, there could be, once the order is signed, a motion for settlement agreement and arguing about all of that, and the city does not want to do that. The city simply wants to be able to have its hearing, which they have the charter right to do. But then the final point, Your Honor, is that I want to make sure that I speak specifically to the counsel in the Gant situation, right? The charter process we've already talked about, but also the hearing procedures contemplate, because they received the possibility of conflict, and it was contemplated from the outset, and the framework was presented to them. And that was on July 17th. The city committed that any charter by the charter that would be conducted before a hearing officer designated by the council in accordance with due process requirements of the 14th Amendment. On August 5th, the notice of charges addressed disqualifying personal or financial interests, prejudgment of the merits, and the inability to decide on the hearing record alone, and barred ex parte communication. The petitioner has not made the showing the law requires. A challenger who contends that combined investigative risk and adjudicative function create an unconstitutional risk of bias has a much more difficult burden of persuasion to carry. That's the Withrow versus Larkin, but that's a U.S. Supreme Court case, Your Honor. That's 421 U.S. 3547 from 1975. Attorney Ash will speak more specifically about that. But the record that the city council set up refutes the prejudgment rather than showing it. The council reserved every finding until the hearing concludes. It said that in the motion. It stated that no final determination has been made and that it will decide each charge solely upon the So they did one in July, they did another one in August. It said nothing in the resolution constitutes a finding of misconduct, prejudge the outcome of any pending investigation, hearing, or other proceeding. The proceeding supplies each protection whose absence made the removal process unconstitutional and lieu missing. It takes that into consideration. This will be outlined in the process. The hearing is structurally separated. A neutral hearing officer presides over the evidentiary portion and shall not participate in council deliberations or vote upon any matter before the council. Right? A separate investigator develops evidence and no officer may exercise the council's subpoena authority independently. The remedy would be for everything that he is talking about to bring to the tribunal. And the final thing is that we sent an email pursuant to the investigative proceedings to Gino Robbins Sr., who is going to preside this Saturday. And we were attempting to schedule a call with him about all preliminary matters. And we have yet to hear from Mr. Kenner about that, even though he did file last night some stuff that he wants to go before the tribunal, but we've yet to hear from him about that. And so, Your Honor, in short, we put in place a proceeding that is fair and equitable and timely pursuant to the charter authority that we have, and we're asking for the court to allow that to happen. And though we do have Councilman Grant here to testify, we also don't want, we're trying to be conscious about the evidence that we have being presented in a proper form and not trying to allow for an end run to allow for evidence to be presented that is properly before the council. And the final point, Your Honor, is that at the end of the day, the city council has the right to make a set of determination. There's no way in which bias could be shown from somebody before they make a decision when they have to get information to make a decision about next steps. Sitting in capacity as a city council person, the information was presented to all of the city council members for them to make a decision about next steps. Based on what they heard, they came out and they made a unanimous decision, 5-0, to go forward with some level of investigation. They had that right to be able to do that, but to assume that the information that they have, that they weren't, that causes a level of bias, would mean that nobody could sit, just like they do with the JQC. They have the investigators and the investigative panel, then make a set of charges. Once they make a set of charges, that investigative panel then sits to determine guilt or innocence. It's the same thing. Sorry?
That's not how that works. But I take your point, but that's not how that works. It's a separate panel after the hearing panel.
Yeah, and that's what Mr. Ash is going to argue. But the point being, Your Honor, is that
But I take your point.
yes,
Yeah.
that at the end of the day, there's no way in which these processes could continue to take place for tons of years without the body getting information that they then make a determination about next steps. But to have gotten all the way here on what would be a request to give a supplemental pleading is too far afield in the first instance to have that discussed, because what it should be and what it is not is the first thing that happened was they were saying that the mayor's powers were limited. That was the TRO. How we get all the way to Councilwoman Gant having to recuse herself based on a set of facts is something completely far from the subject matter jurisdiction of the initial complaint they had, and it's not an amendment or a supplemental pleading. And so that's our position. Mr. Ash will speak to the due process constitutionality.
Good morning, Your Honor. In the interest of efficiency, my job here today is to talk about what constitutional due process actually requires and what the evidence would have to be to show a due process violation. Because if there's not a due process violation, if they can't prove one to essentially a matter of law, then they have no right to equitable relief here. I'm happy to do that now, or I'm also happy if the court would like me to reserve that until evidence comes in.
I would prefer you reserve it. That would be my preference.
Thank you, Your Honor.
And I also note for Mr. Washington that except for your exhibits, almost everything that you've argued was part of your August 16 filing, so I did have an opportunity to review that.
Councilmember Ant is, as far as I know, the only member of the Stockbridge City Council who's here today.
Councilman Barker.
Excuse me, sorry. Didn't turn far enough.
Oh, get on up there.
How does the court wish to address the council members' attendance?
If Councilman Aaron is going to be a witness, then she should step out. If Councilman Barker is going to be a witness, then she should take on
I don't know who Mr. Kenner intends to call.
which is why I'm leaving, and I also do not know, which is why I'm leaving it to you guys to make sure the rules and votes. So if there's anybody who is going to testify as a witness, who is not the first witness, then they should step out of the courtroom on both sides. That includes Councilman Aaron.
Smith,
Say it loud for the record, Mr. Cameron.
Bruce Smith.
Mr. Smith, if you'll watch your step as you come up, please watch your step. All right,
Trying to
before
make it
you sit down, if you'll raise your right hand for me, please solemnly swear and affirm that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God. You can have a seat, please. Once you see this sir, you will lower the entire mic down to your face. Pull that whole thing down, just not the top, the whole thing. State your name for the record.
Bruce Smith, Senior.
Witnesses will be Mr. Cannon.
Thank you, Your Honor. Mr. Smith, good morning.
Good morning.
Mr. Smith, do you know a person by the name of Lakeisha Gant?
Doing very well.
And how do you know Ms. Gant?
I've been on this gas over about 22 years, working on her, and she's the city attorney, for the city of Stockbridge. And, I was instrumental in helping her get elected to council back, 16 years ago.
Okay. I don't know if everyone can hear you. Can you come up a little bit to the mic, sir?
I can hear you.
Okay.
You can.
All right. So you say that you've been knowing Councilwoman Gant for about 16 years?
Yeah, well, over 16 years.
Okay. And do you have, on occasions, have you communicated with her over the telephone, cell phone, or anything like that?
Yes,
Do you have her cell number?
yes,
And do you have her cell number or so along with her information or picture or so in your phone?
yes.
How, when she calls, how are you able to identify that it's her who's calling as opposed to anyone else?
She's one of my contacts.
Okay. And how often have you and Ms. Gant communicated via the cell phone or telephone?
Numerous times over the years, concerning elections, concerning some other things that I can't discuss about that part, but yeah, mostly political stuff.
Okay. Now, have you and Ms. Gant ever exchanged text messages?
Yes,
Did you have the occasion to communicate with her regarding Mayor Williams via
yes,
text message?
yes.
Prior to any text message between you and Ms. Gant, did you communicate with her over the phone?
Yes,
And I'm specifically talking about text messages, recent text messages. Did you speak with her about any investigation or any allegations concerning the mayor?
because I do a lot of social media, digital creation stuff, she saw a post I made about the entire Stockbridge City Council and what my opinion was about the thing.
And before you get into that, what platform was this, that post?
This is on Facebook,
Okay. And was it on your Facebook page or on someone else's?
so it's on my page.
And is your page, is it in your name?
It's Senior Smith.
Okay, all right. And what post did she see that you made?
The one about, I was criticizing council for some stuff that they were doing, and she was named in there, posted along with a couple other council people. She called me, Saturday morning,
You say Saturday morning?
on Saturday morning.
Do you recall the exact date?
I don't have it, so I get my phone, but,
Was it recent?
it was recent, within the last 3 weeks, it was recent.
All right, go ahead.
And she started getting on my case about the post that I made. And somehow it morphed into a discussion about the mayor.
Okay.
In that telephone conversation, she was telling me that we have a lot of evidence against him, we have this, we have that, and all this other stuff, so she
Okay,
started
okay,
saying.
hold on. Not to cut you off.
Okay.
But you start off saying we have a lot of evidence against him, we have this, we have that. We don't know what this and that is.
Right.
So can you tell us, if you can recall, you said that she said that we have a lot of evidence against him, and now what's the this and the that?
Okay, then it started morphing into, I can show you, I got text, I can show you. Okay, in one of her texts, she sent, we have evidence that I would not want my kids around him or something like that. Okay, that's what she texted.
Now, let me ask you this. Did she, was this communication, after July the 17th of this year?
No, it was, I can't recall, because it was right around that area. Right?
Well, let me ask you this. Did this conversation take place after the mayor was, his privileges were, or his administration leading?
Yes.
I will go leave objection. Ask the question again for the
Was,
record.
yes. Do you recall if the mayor had already been restricted from a lot of his administrative duties?
Yes.
So, do you recall if this conversation came about, after the council had given a resolution and had set a date for a hearing?
I believe so, yes.
Was this conversation, after the council had drawn a resolution and indicated they were gonna have an investigation about basically allegations regarding the mayor?
To the best of my knowledge, yes.
Okay, so all this came after that?
Yes.
All right, and so did she tell you specifically what type of evidence, so to speak, that she had against, that she knew personally that she had against the mayor?
She indicated that they had a lot of stuff against him. And in her text, she sent me some other texts and stuff like that. And in her text, she said that I would want my kids to be around him. Okay, that gave me an opinion of what she was talking about. And it wasn't good. So she kept on and kept on and kept on. And I started telling her, Keisha, shut up, stop talking. Stop talking, stop talking, stop talking.
And why'd you tell her to stop talking?
Because she was telling me stuff that I had to relay to the mayor, because now you've accused this man of something that's not true. And
So let me ask you this.
matter of fact, I can tell you when it was. It was a week before. It was a week after the first initial press conference. I think that was a Monday. And then it was between that week and coming back to court the next week. Between them put out that next thing about him, the bottom part of the allegation. Because the bottom part had not been put in, and that's what we were talking about before they put that in there. Okay, so yeah, that was in that week right there.
Okay, all right. Now, but she was never, she just said that she wouldn't want her kids around the mayor, but did she ever get into detail?
No.
All right.
I mean, she just kept rambling on and on and on. And then, all these text messages and everything, I even sent her a text message back about somebody alerting me to what was going on. And that opinion was the same as the opinion I formed from this game.
Okay. All right. I'm gonna show you, as smart as PD contained therein?
Yeah,
Do you need a moment to see if it refreshes your recollection and make sure that it's the way you saw it back when you received it, without reading it?
yes,
Okay. And can you, without going into the contents, can you tell the court exactly what is considered to be identified as P1?
these 3 pages,
Yes.
yeah, this is, yeah.
What is it?
This is text messages between Jakeisha and I.
Okay. And how do you know that those are text messages between you and Ms. Gannon?
Because the stuff that's in here, yeah, it's text messages, yeah.
Are you able to identify it by her telephone number? And was that communication that you and she had during that time?
Yeah, like I said, when she called me that Saturday morning, it was to get her out, take her off my page.
Mr. Smith, I need you to be responsive to the question of the attorney.
Oh, I'm sorry.
Ask the question again.
Is that question again?
The question is, how were you able to determine that that was a text message that was coming from Ms. Gannon?
I was on the phone with her when she sent it.
Okay. And are those text messages associated or so with her telephone number as well?
I don't see it on my own here, but yeah, this is what I have, yeah.
Okay. And you have communicated with Ms. Gant through that number in contact in Texas before?
Yeah, personal cell.
All right. And did you personally receive those messages on your phone?
Yes,
Have the messages or anything contained in P1, have anything been deleted or altered or anything like that?
as far as I know, no.
Do they appear to be in the same type of condition in the way that they were when you were communicating with her through text?
Yes,
Move to admit P1, Your Honor.
Any objection to admission of P1?
No, Your Honor.
Submitted without objection.
All right. Now, you indicated that you were talking with her first and then she started texting you, correct?
yes.
All right. Can you read, for the record, exactly what Ms. Gant said to you? And then I'll ask you to explain later.
In this telephone conversation, it was actually 9 minutes long. She was getting on my case, as you see on the first page.
Once again, the question was, can you read, and Mr. Kenner asked you to control responses to make sure they're responsive to the questions that you're asking. The question was for you to read the document, and that is what we need you to do.
Oh, okay.
Your Honor, may we request a copy of P1? We don't.
It's in the pleadings, it's been filed.
Okay, we don't know that. Is it the
I don't
thing that was attached to your motion?
Yeah, it's been attached.
Okay, cool. Then, but we hadn't established that. Thank you.
Go ahead, Mr. Kenner.
All right. Can you read it, sir? And we'll explain later.
You want me to read the document?
Yes.
Okay. Would you like me to pull something out of here?
Yeah, I want you to read the entire thing.
Oh.
Conversation between you and Ms. Gant.
Please stop including me in nonsense. No one would put forward and say, man, that is ridiculous. No one is trying to make.
Okay, hold on. You're going to have to slow down a little bit, okay? And you kind of talk up. Go ahead and start over.
Please stop including me in nonsense. No one would put forward as city manager. That is ridiculous. No one is trying to make up the mayor. That's absurd. Please stop. We can't let the mayor do his initiatives. He doesn't need to be around minors, as far as I'm concerned, not until we saw all of what was given to us out. We can't. So yes, GMA attorney advised us to suspend things now. If you knew what I knew, you would agree. A little bit out of order here. I don't want to see any one of us fail, not even Marvin. It's bigger than this. Please stop including me in nonsense, or else begin that one, the first one there. And here's the other one here. What don't want to share these messages. I don't, but I'm not going to sit here and just get attacked. We have tried. I promise you, we have tried to tell him. We have complaint after complaint after complaint given to us. It was becoming so bad that if we didn't do anything, we would be held liable. We tried to keep this under wraps. We even had a council meeting from 6 on Friday so that no one would know. We have to post, we have to post in the newspaper, but we don't have to blast. And we didn't, and we didn't. He did. He brought family and friends up. He put attention to this. And I'm just going to say this. I love us, all of us, and I will do my part to protect us. But after warning, after warning, after warning, and then to get paperwork saying you either do something or you can be held liable, we're left with no choice. That's what I have now.
Okay. Anything else?
That will be it.
Okay. Now, after you received those texts, you had already spoken with her earlier, correct?
Right.
And then she texted you those things.
And during our conversation.
Okay. What was your perception when you received those text messages and your communication with Councilwoman Gann in terms of whether she had already prejudged this case?
Your Honor, that causes speculation.
Two things. One, I'll sustain the objection. Two, you guys decided who's out here handling this witness. There's only one.
All right. Let me ask you a question. In your opinion, receiving those text messages, did you believe in your mind that she had already formed that opinion?
Objection, Your Honor. It's called speculation.
In his opinion, Your Honor.
I'll sustain the objection.
Okay. All right. Since then, Mr. Smith, have you spoken, since you received those text messages, have you spoken with Ms. Gann?
One other time when we were in court, when I was in court last time, she was unhappy being included in this.
Okay, what did she say?
I trusted you to keep in my chest and I went out the door.
Okay. And when she said she trusted you, what did she mean by that?
That these text
Objection, Your Honor, causes speculation.
His perception, Your Honor.
I'll allow that. Go ahead, sir.
my opinion was that she was upset that these messages got to court.
That's all I have.
Mr. Washington, you have questions for Mr. Smith?
Yeah. All right, Smith, can you go back to the text messages? You read a part where it said that they were trying to sort this out. Is that correct?
Yeah,
All right, and what does that mean?
my opinion.
Yeah.
My opinion is, they didn't have anything, and they were trying to pull us something. That was my opinion.
Okay. So them trying to sort it out was they didn't have anything, and they were trying to come up with something.
My opinion is the council's dysfunction has been dysfunctional for a minute, a long minute.
Okay.
My opinion is that they were trying to sort this out, that they were trying to come to consensus. My opinion is it was not by the vote that they were having a problem with in that.
Okay. And have you supported Councilwoman Gant in her elections and voted for her?
I supported Gantt in every election she's been in since she was city attorney.
Okay.
Matter
And
of fact, all of them except for 2 council people that's not sitting and the former mayor.
okay. Would you say that what are your thoughts about Councilwoman Gant?
For this part here, she's wrong, in my opinion.
Okay. And what is she wrong about?
Because I know Jayden, I watched Jayden grow. I know Councilperson Gann. I also know her challenges that she's been through. But my opinion is that this entire council is trying to get rid of this man for no reason whatsoever. My opinion.
Do you know, you've been asked about these text messages and all that stuff? When you were texting back and forth, what were you all talking about?
Me taking her off my Facebook page for me. You gotta understand something about my Facebook page. My Facebook page started back then, and it's blown up to where everyone now is talking about the issues that I raised back then, from the amphitheater all the way up to right now. And it's caught on fire. That's what I do. I'm a political person. To get her elected over and over and over and over, yeah, it was at-large thing, and you had to deal with not-in districts. So I couldn't support her in our district because I was supporting someone else in that district too. But the whole point is that they have formed an opinion that he should not be in office. And this here, my damaging opinion that she's saying in here, you know, that's not fair. That's not fair at all. And then to show you how damaging it is, the first time the city put out a statement about it, the sexual stuff was not there. And this text here was in between that period of time, which you put out another statement the next Friday that the sexual stuff was there. And we were talking about this in between that time frame.
Okay, I want you to go back. Do you have your phone with you where you were texting Councilman Gann from?
Our phone is back there.
Okay, what were the dates, and if he needs to go get it, I'm fine with that, Your Honor. I just want to know the dates of these texts, because they're not on the text.
What's the question?
Okay, what were the dates? If you looked in your phone, would that refresh your memory of what the dates of the text you got were?
It's not first indicated, you just not remember
Okay.
that, so there's no reason to.
Do you remember the dates that you were texting?
I can tell you exactly that the text message was in between that 2-week period.
Right, but what?
A 1-week period.
Okay, do you know the date exactly?
I don't know the date exactly. It was probably a Tuesday.
Okay, if you looked in your phone, would that refresh your memory of the date?
It probably would.
Okay.
But
May he be able to do that, Your Honor?
No, you can't.
All right, I would like for you to go do that so you can tell me the exact date, sir.
No,
Yeah, first.
yes, go ahead, move about three.
just wait for it to warm up.
And what's the name of your Facebook page?
C.M. Smith.
C.M. Smith?
S-E-N-O-R. S-E-N-I-O-R.
I'm sorry, what did you say?
Senior Smith.
Senior Smith.
Senior.
Senior
Well,
Smith.
senior.
Is it S-E-N-O-R or S-E-N-I-O-R?
S-E-N-O-R. So you got 3 of us in the 2 4. Bruce Smith, and got Jimmy the 3rd, the 2nd, Senior the 4th.
Senior Smith. Okay.
Let me, is that your phone that you're putting on?
Yeah.
Okay. Let's turn the, ringer
Monday, July 20th?
Yeah.
At what time?
Our post was at 5:40. See,
And the last text you received from her, so all the texts that you had.
Before we move forward, let me just clarify, Mr. Smith, the July 20th date, is that the date that you make the post to your site, or is that the date?
that's the date she's responding back to me at 5:40.
So July 20th at 5:40 is when these text messages start.
Right.
Okay.
And when was the last of those texts that were put in as the exhibit? What's the last date that you texted with her on that exhibit?
That would be. That would be that Monday. And there's more in here on my phone, Mr. Sandra, right here.
Right, we're just talking about the stuff that you put in evidence. What's the last date of those text messages?
That would be the 20th.
July 20th,
Yeah.
and that's that 5:40 text exchange.
Hold on, man. Last text I sent her was on the 21st. Says, don't get girl and don't you forget to have a box of product down.
I'm sorry, what'd you say?
She had another one, I'm sorry, I'm killing again. The 25th was another one, was a text. That's when she got, please stop taking my name out of the conversation. I don't know what you said, I told you directly, but that kind of thing.
All right.
That's not presented here right now.
All right, so the text message you have in front of you, is it a fair statement that all those texts were July 20th at 5:40 approximately?
And July 25th.
And July 25th.
Yeah.
What was the July 25th text?
Is
No, in the exhibits that you have.
it's in these exhibits here.
Right, that's why, read the July 25th text for me, please.
July 25th text on my phone here.
Oh, here,
Please.
yes.
All right, 25th text I don't have, it's not on here.
Okay. So in reading those sheets that are in your hand, are all the dates from those July 20th?
20, I said 20,
Yes.
and it'll be the 20th, but there's no damage stuff on the 25th.
Okay. So July 20th is, I wanted to be clear, so July 20th is the date of those texts.
Right.
Okay. And
Well,
you,
to the best of my knowledge, yes.
okay.
I don't-
And you then texted the mayor after that, right?
No, I talked to him, man.
Okay, so you talked to the mayor after that, right?
Yeah.
And did you text with the mayor about this topic?
I told him what I thought was going on.
Okay. And that was around that time as well?
Yeah, because to the best of my knowledge, he didn't know what was going on.
Okay. All right, I have no further questions right now, the witness, Your Honor.
Mr. Chairman, is that cause been hot in reading room?
Yes.
Mr. Smith, so since counsel opened the door as to the July 25th text, you said that there were some text messages between you and Councilwoman Gant on the 25th?
No, I don't think that's a fair characterization.
Well, okay. Well, he asked him about it.
Well, he did not ask him about it. He was very careful in asking him to refer to messages that were actually in evidence. And Mr. Smith received several further than the scope of the, that you would do that for.
Okay, all right. Well, let me ask you this.
Okay.
You had multiple conversations with, it appears you had multiple conversations with Ms. Gant after July 17, 2026, is that correct?
Right.
The first conversation that you had with Ms. Gant was in response to a post that you put on Facebook that was on July the 20th, 2026, correct?
Right.
All right.
About that time, yeah.
All right. And you had another conversation with her. Was that verbal or was that just through text?
from here with text, text and verbal.
Okay. What did she say to you verbally?
And no, I'm going to object that this is outside the scope of my cross, because we stopped at his exhibit, which was July 20th. And so if it's outside of that date, I'm going to object to being outside of the scope of his direct and my cross.
Well, Your Honor, it's not about being outside the scope of the cross. He asked him about July 25th, the communications. So therefore, I have a right to ask him about all communications, because whatever communications he had with Ms. Gant is germane to the issues before the court.
It is not my recollection that Mr. Washington asked Mr. Smith about July 25th. It is my recollection that Mr. Washington was trying to get Mr. Smith to give him the exact time frame of the messages that he received in P1. It is Mr. Smith that introduced the idea of July 25th, and Mr. Washington then continued to say to him, is that on the page in front of you? He indicated these pages, and then he looked at the pages in P1 and said they are not here. Tried to read July 25th, was redirected to what is actually in P1. So July 25th is not a door, as you say, that was opened by Mr. Washington. And so unless you have a question that seeks to evaluate or extend or expound upon his cross, to that extent, I will sustain the objection.
Okay. You indicated that when you spoke with Ms. Gant on the 20th, you understood that the council had initiated an investigation, is that right?
Right.
Okay. And I believe you indicated that you thought that this investigation, I'm not saying it the way that you said it, was senseless or so.
I would say they were trying to find something to put on the map,
Okay.
my opinion.
All right. And did Ms. Gant tell you that they had already started this investigation and she was receiving information from individuals?
No, I object to leaving.
Not a further objection. You can ask the question.
Did she indicate to you that they had already started the investigation and that she had already started receiving information from others based on allegations?
She indicated that they were getting numerous complaints after complaints after complaint. That if they didn't do something about it, they were gonna be held liable.
Okay. Now, one of the text messages that she sent to you was, "We can't let the mayor do his initiatives." Did she talk about that? Did she say why?
That was a ramble. I have no clue as to what she's talking about there.
Okay. And she also said he doesn't need to be around minors as far as I'm concerned. Did she tell you why she was saying that?
That wasn't exposed to opinion. She didn't tell me that, but then I formed an opinion that anybody that with a reasonable mind would come to my same conclusion what she was saying about that.
Okay. Did you understand that she was making an allegation that there may be some criminal implications?
Yes.
When she said, "If you knew what I knew, you would agree," did she explain what she meant by that?
No.
When she said, we have complaint after complaint after complaint given to us," did she tell you what those complaints were?
She said numerous complaints. People complaining. The mayor's doing this, he's doing that. No, not mayor, Jayden's coming. Jayden's doing this, doing that. I tried to get him, try to counsel him, try to do this, all sorts of stuff.
When she said you don't know half of what's going on, did she explain what she meant by that?
As far as counsel is, I wouldn't believe it. What? Half what's going on, you really don't know what's going on in Stockbridge. So, my opinion is they were confused about what they were trying to do.
Okay. That's all I have.
This witness can be excused then.
Yes. Yes. Yes.
All right, thank you, Mr. Smith. You'll watch your steps as you get down.
Good morning, Ms. Thomas.
Good morning.
Do you know Jayden Williams?
Yes, I do. He is my grandson.
Okay. Do you know a young lady by the name of, or councilwoman by the name of Lakeisha Gant?
Yes, I do.
And how do you know Ms. Gant?
I know Ms. Gant from the political arena.
How long have you known Ms. Gant?
I would say 5 years.
You say 5 years?
Mm-hmm.
Have you ever had the occasion to speak with Ms. Gant over the telephone, cell phone?
Yes,
Do you have a contact in your phone for Ms. Gant?
I do.
How often in 5 years or so do you speak with Ms. Gant, or have you spoken with Ms. Gant? Is it all the time? Is it once a month?
No, we are not social friends.
Okay.
We have cross paths in the political arena. We have cross paths for different community events. So most of the conversations are around something of that nature.
All right. Now, do you have her cell phone that's associated with her name in your as a contact?
I do.
And have you, on occasions, text with Ms. Gant?
I have.
Back and forth, has she texted you, you text her?
Yes, I have some dates back to 2024. We were working on some domestic violence things. There are several opportunities that we share text messages.
Okay. I'm gonna draw your attention to July the 21st, 2026. Do you recall having a conversation either via the telephone or via text with Ms. Gant?
I do.
And I'm going to show you what's been marked as P2. Ms. Thomas, can you take a look at P2 without reading or describing, reading the contents? Can you tell the court what's being shown in P2?
Apparently, I'm looking at you said not to describe it. I'm trying
No,
to
no.
determine.
Don't read the content. You just
Okay,
write
don't read the content.
Let me answer that. Ms. Thomas, I need you to lift your voice if you will come in a little bit closer to the mic and vote for us. I'm having a hard time hearing you.
Okay.
Go ahead.
Okay. I'm looking at what appears to be the history of a phone call that was made.
Was it a phone call or was it text?
The one that I'm looking at now says incoming call, so it is a phone call.
Okay. That's the first page?
It is.
Can you turn the page and tell the court what you see after the first page?
I'm looking at what appears to be text message that took place.
Okay. Now, you testified that on the first page, it appears to be an incoming call. What's the date?
It says incoming call, July the 21st.
Okay. And who called you?
This call was made to him from Lakeisha Gant.
All right. And did you and Lakeisha Gant have a conversation when she called?
Well, it's not really a conversation. conversation that lasted 53 seconds was more of an announcement, not a two-way conversation.
When you said announcement, what do you mean by that?
When she called, she said, don't say nothing, just listen. That's what the first words.
Okay. And what did she say?
She said, and it's not word for word, because I don't remember word for word.
Okay.
She said, you need to have him resign. We have what we need against him. We don't want to hurt him, but he needs to resign. And I went, and she said, don't say nothing. And that was the end of the conversation, 53 seconds. So not a conversation per se, because the only part that was really stated was from her.
And this call was made July the 21st,
July 21st,
which was after July the 17th, 2006, when the mayor was, well, when the resolution was drawn. Is that correct?
yes,
Was it after the mayor was restricted of some of his administrative duties?
you would have to remind me of the date that he was restricted.
July 17th.
Okay, yes,
Okay. Now, I want to draw your attention to P2. I believe you indicated that those were text messages that you received from Ms. Gant. Is that right?
page 2 is, text messages received from her.
Okay. What about page 3, 4, and thereon?
Page 3 is a response from me and an additional message from her.
Okay. And was this in the same, those text messages, did you receive those text messages at the same time, or were they over days? Or was it a continuous text message?
The incoming call came on the 21st of July. The text message, first one came on the 21st of July.
And
I responded on the 22nd of July.
okay. Why didn't you respond? Let me ask you this. Did you receive her first text message on the 21st?
I did.
And why did you wait until the 22nd to respond?
It was very troubling to me. I had needed some time to consider what was going on. Why would someone from the opposing side send me information knowing I'm the grandmother? And I had to consider, do I take an opportunity to save him, my grandson, looking past the political thing? Do I try to take an opportunity here to save him, the grandson, or do I continue the battle from the political perspective? Because this goes beyond, from my perspective, goes beyond a mayor. This is someone I'm proud of. This is my grandson. So a door has been opened that I had not considered. And this door is basically saying, pull him out now and save him, or go forth and risk him. So as a grandmother, I had to pray, I had to think about it. In fact, I responded and said, I had to pray and think about it.
Well, don't read that yet. We'll get to that.
Okay. So I was troubled. I couldn't answer the same day because I had to think through what was I doing? What do I need to do as a grandmother for my grandson?
Did she ever tell you during the conversation when she said, don't talk, just listen? Did she tell you where she was getting this information from, other than her just saying he needs to resign, things of that nature?
No, she never said what information was coming from.
But she said, did she say she had received information?
She said we have information.
Okay. Now, I want to direct your attention to the text messages. Those text messages appear to be in the same order. Have they been deleted or has been modified at any point? Can you review them to make sure?
No, they have not been modified. They're in the same order.
Okay. And you received those text messages, correct?
I did.
And you received those text messages from Ms. Gant?
I did.
Move to admit P2, Your Honor.
Any objection to the amendment of P2?
No, Your Honor, I just wanna make sure there's just the two, there's the incoming call, and then there's the text after that, it's just 2 pages, is that
No,
correct?
it's more than, there's a
Two
city.
minutes, spit out the gun. And then Mr. Cameron, you can show Mr. Washington the exhibit so that he's able to see what is in your offer.
Sorry, but you have it. Yes.
I'm fine with it, Your Honor.
P2 is admitted without objection.
Ms. Thomas, can you read for the court the text messages that you received from Ms. Gant?
Listen, I know Jayden is young and didn't know who to trust. I have had several discussions with him on some of his behavior. I'm telling you out of love, I would strongly consider resigning without putting out allegations. People are coming to us with stuff that although some can just be embarrassing, other stuff can be detrimental to his life, his entire reputation. And being a civil versus a title will at least dilute the situation. That's just my opinion. Now, Griggs just put out the TRO that Jayden's attorney filed. If he's having a hearing of all this embarrassing stuff, it's going to come out. And there are like 4 exclamation marks after come out. I'm not trying to coerce you or anything. Shall I go to the next page?
Yes.
So that ended that page. At the next page, which is for July the 22nd, I said, I had to pray and think about it. This is not enough. More's needed to shift my thinking process. She responded, yes, I'm aware, but remember, I tried to warn you. The next page. Yes, I'm aware, but remember, I tried to warn you. You know I'm personally coming to you. I mean no ill will. I took a big risk in doing so. I cannot disclose any information and won't. But if he wants to have a hearing to get his suspension removed while this investigation takes place, so be it. I can't force his hand, nor yours. I was just trying to dilute the outcome of what could be a disastrous if the allegations are true. it can be embarrassing, potentially criminal. My thought is he is young and can bounce back from this. If the allegations are found to be true, exposed, it could ruin him. I honestly think he should let the investigation, and it is investigation, do his job. And prior to any hearing, counsel will allow him to review the investigator's report. He can make a decision there. That's my thought. But just know, I wouldn't come to you if I truly wasn't concerned about the end results could turn out, how the end results could turn out. I'm sorry I tried. I did not respond to that message,
Why not?
the second one.
Why not?
One was very troubling to me, that a council person who's also an attorney would send this type of information to me, knowing my stand in the community, knowing that I am his grandmother, and to make the statement, we will let him see what the investigators find and let him make a decision. What are you gonna do now, sneak information to him? I mean, to let him see it and then let him make a decision? And then it left from being about his performance as a mayor. None of this is talking about his P card. None of this is talking about the work that he does. It says embarrassing. What have you done? Potential criminal. So put me in a position again. Am I putting him out here to be totally embarrassed when he's building a career of service? You said criminal. He's been in there 6 months. Did he steal something? Did he destroy something? So it put me in a situation of, what do I do with this information? Then she makes a prediction. He's a young man. He can bounce back. You don't have the right to determine if he can bounce back. You don't have the right to determine the impact this has on his future about any allegations, because whether I did it or not, the allegation gotta come out sometime, somewhere. So how dare you start playing like you have this power to determine, oh, he'll bounce back. And then to go on and say, if the truth is exposed, it could ruin him. He's 22 on his birthday. He's 23 now. Where was the time of the transition, if there was anything that needed to happen to groom? So I'm put in this situation of a grandmother wanted to do protection for my grandson. Or in a situation I had happen to me, I said, come on, bring, I'm an old coon. Well, you want to destroy the entire future, and she states that, could ruin an entire future or career. And I don't think that was fair. So I decided then, I am not going to respond to this because there's too much in it. Too threatening. I lost sleep over it. I'm not focused because of it. I could not focus during the day. I had a lot going on in my life. And to have to deal with this trauma on top of it was too much, and that's when I decided I would let him know and let his attorney know.
Now, based on the text message that you received from Ms. Gang, were you under the impression that she wanted you to tell the mayor to step down and resign?
Absolutely. Absolutely. She stated it in one of them.
And this was before any conclusion of any type of investigation, is that correct?
Correct.
But before the investigator had already done his job, she was trying to coerce you, or so, well, she said she was not trying to coerce you, but she was trying to urge you to go to the mayor.
Objection, Your Honor, what do you think still?
Counsel said no objection.
What was your impression of what she was directing you to do or asking you to do?
Objection,
I
ask
don't
and
know.
answer, Your Honor.
I will leave that. Ask the question again so the witness can answer.
Yes. What was your impression from speaking with Councilwoman Gant and receiving those text messages? What she was asking you to do?
I am a grandmother, and I think it's obvious even here. I don't want my grandchildren hurt. And I believe with all in me that she wanted to influence me to influence him to resign, not fight, not go forward, to let this matter pass by without any fight or hearing.
Now, do you have Facebook?
I do.
Do you know if Ms. Gant has Facebook, a Facebook account?
Yes,
Are you familiar with her Facebook account?
yes.
Have you been on her Facebook account in the past?
I have seen it and read it, but I have never posted on it.
You never posted on it, but you've seen it and you read it.
Yes.
And have you ever seen any type of post made by Ms. Gant?
Yes.
Have you ever seen a post made by Ms. Gant that's not necessarily on her Facebook account, but on others?
I don't know how to determine that. I can tell you I have seen the posts on her Facebook account. I don't know how to determine if they on other Facebook accounts or not. That's what I'm saying.
I'm gonna show you what's been marked as P3. Yes, Your Honor. I've already shown, Counsel.
Was this P three?
Yes. Ready? Okay. I understand. Let me ask you this question. After you received those text messages, did you later see some posts or comments by Councilmember Gant on Facebook concerning Mayor Williams?
Objection leading, Your Honor.
Yes, I did.
Okay. And when you saw those posts, were you concerned, were they concerning to you?
Absolutely, that they were extensive. I noticed that they have a lot of information.
Do you know if the post that are you are familiar with the post from Councilwoman Gant?
I know who they was from, yes.
Okay. And did you see the conversation, at some point, did you see the conversation and comments going back and forth between Councilwoman Gant and other members of the community?
Absolutely.
Objection, Your Honor. This calls for speculation, and most importantly, I don't know how these witnesses testify about what she even was saying if she was not a part of the intake where these conversations take place.
Now, the post, Facebook that you saw, how were you able to identify, looking at the post, the Facebook comments, that was Lakeisha Gant?
Her name is in the comments too.
Okay.
And any Facebook post on
Okay. And what about her picture?
her pictures next to me.
And you have been on her Facebook account before, is that right? And have you seen the same picture or so that's next to the name in these posts? When you looked at those posts from Ms. Gant, was she discussing what was going on with the mayor?
Yes.
And was she discussing about conversations or interactions that she even had with the mayor?
Yes.
Did the post and the page identified Ms. Gant or Councilwoman Gant, or otherwise identify her as the person that you know. I'm sorry, that was a poor question, I'm sorry. Did the post, or the Facebook post and page that you saw, did it identify Councilwoman Member as the person that you know?
Based upon her name and her gifting, it does identify as a person that I know.
Move to admit P3, Your Honor.
Yes, Your Honor, I'm going to object because I don't know, well, I don't know, first of all, what it's coming in for, but second of all, that this is a business record, there's no attestation that it's a business record. But if, I don't know how, as I was saying earlier in my objection, how a third party can attest to the authenticity of conversations between other people on a website that they don't own or control or know how that works. Because as you know, in the world of social and digital media, that could be Councilwoman Gant, it could not be, but that threshold they won't be able to cross based on her knowledge of not only Facebook, but Councilwoman Gant herself.
Yeah. Yes, Your Honor, it's not for the truth of the matter asserted, Your Honor. It's offered to show that Councilwoman Gant was speaking about the investigation. She was speaking about the facts of this case. And I would add, Your Honor, that Branch versus State, which is a 2021 case, the citation is 361 Georgia App 86. In that case, Your Honor, the victim testified that she received texts and Facebook messages from Branch. The defense contended that the electronic messages were not adequately authenticated. The Court of Appeals held that Georgia has no special authentication rule for text or face messages. The recipient's testimony made a prima facie showing that the messages were what the state claimed. Any remaining challenge to who actually authored the messages went to the weight, not to the initial admissibility. Also, Pierce versus State. In that case, Your Honor, there was the citation, I'm sorry. Pierce versus State, citation is 302 Georgia 389, which is a second one is Pierce versus State, Your Honor. The site is 302 Georgia 389. That is a 2017 case. photos of text displayed on a recipient's cell phone were offered. The alleged sender denied authoring the messages. The state did not offer carrier records, and no one saw the sender type them. Supreme Court held that messages were sufficiently authenticated. The recipient recognized the number, explained how he knew it belonged to the alleged sender, described exchanges, and the content matched other circumstances. And that's dealing with text messages. But also, I want to specifically talk about Facebook accounts. Also, I direct the court to
The 302 Georgia 389 Pierce, you said that's text messages, not Facebook.
correct.
I ain't listening to
I'm gonna.
you.
So we've got Henry LP, 324 Georgia App 78, which is a 2013 case. And what happened in that case, Your Honor, Facebook printouts were attributed to a juvenile through a nickname, photographs identifying biological details, and an officer's testimony that the printouts accurately reflected the page viewed online. Court held that Facebook material was sufficiently authenticated. Any dispute about who owned or controlled the page went to the weight rather than admissibility. The next one, Your Honor, is Holly versus State. The site is 363 Georgia App 107. It is a 2022 case. And in that case, Your Honor, a relative recorded a Facebook video from another phone and authenticated it based on familiarity with the defendant's Facebook account and the people shown in the video. The Court of Appeals held that testimony by a witness with knowledge combined with a fair and accurate representation of what the witness observed was sufficient. The court repeated that authentication requires only a prima facie case, after which authorship and accuracy disputes go to the weight. So when counsel is talking about we don't know if she said it or what, that goes to the weight, not the admissibility. I have another one, Your Honor. All right. The other one is Inteman versus State, spelled Intemann versus State. The site is 358 Georgia App 488. It is a 2021 case. 488? Yes, it's, okay, I'm sorry. 358 Georgia App 488. 2021. And in that case, Your Honor, the state offered tweets attributed to the defendant. The Court of Appeals held that social media evidence may be authenticated by circumstantial evidence, including account name, handle, profile picture, content, and testimony from someone familiar with the account. Once the prima facie showing is made, authorship disputes go to the way. And so in this case, Your Honor, the witness has testified. I think she's laid the proper foundation. As a witness, she's identified the account by name of Ms. Gant. She's familiar with the account. She saw the profile photo. She's familiar with what Ms. Gant looks like. She understands that Ms. Gant holds public office. She's familiar with her prior posts, and she's familiar with what was said in all the statements and comments in the post. So I would move to admit P3, Your Honor, under the various case law that I've indicated. These statements do not go to the truth of the matter asserted, so they would not.
detected and located the evidence by the county, preserved the same photograph, and verified the printout accurately reflected the color. Intent therefore supports submission only when the proponent supplies comparable account-specific familiarity and corroboration, and an uninvolved third party who attributes the page cannot supply that foundation. In the interest of LP, it is, especially for the list sets out required secret, the proponent must first authenticate the web page printout as an accurate representation of what appeared on the computer screen. There's no way in which Ms. Thomas will be able to do this. There are like 50 different people here. And the other thing is that the actual authenticated evidence, if we're trying to, if this is trying to come in from Facebook, and we've dealt with this for years as a business record, there's standards that it has to meet, but I'm still unclear as to if he is saying that it does not come in for the proof of the matter asserted, right, then it's hearsay. But I'm still unclear as to what exception to the evidence code we're trying to bring this in under. And because self-identification, which Patterson v. State, which is 287 Georgia, Act 100, reinforces the basic principle that self-identification alone does not authenticate a speaker, but a witness lacks independent knowledge of corroboration by this. And so we don't think that there's any way in which, and the final point of this, is that Ms. Gann is here, is going to testify. So if he wants to ask questions about that, he can ask Ms. Gann, but I don't think Ms. Thomas can have an independent knowledge to meet the authentication threshold for this. And we're still not clear as to whether it's coming in, because there are certifications, et cetera, there are notaries and all that stuff necessary for space for it. But if you move from that as a business record, I don't know what the evidentiary exception is that it's coming in under, especially if he says it's not for the truth of the matter asserted, which I think it is.
Last one, Mr. Mayor.
Yes, Your Honor. First of all, Your Honor, I'd like to direct the court to Myrick versus State.
Say again.
Myrick, M-Y-R-I-C-K versus State. Site is 306 Georgia, 894. It's a 2019 case. And Your Honor, I don't believe that this is hearsay, because we're not offering for the truth of the matter asserted, which is we're not offering to establish that what Councilwoman Gant said that the mayor did not do was true. We're not offering to show that he did commit some type of violation by using his P card, or that he wrecked a vehicle. That's not why we're offering it. This is being directly offered to show that Gant claimed the knowledge about what's going on, asserted that she had received complaints, said she gave warnings, called conduct wrongdoing, predicted consequences.
This is the, you said Myrick, M-Y-R-I-C-K?
Yes.
It's the Baskin Challenge. Give me a piece of that.
Well, basically the reason why I use that case because it says the Supreme Court held the detective statements are not hearsay when used to show the interrogation technique and the effect on the defendant as a listener.
Give me a piece of that.
Ma'am?
Give me a piece of it.
What?
Your piece of it, so I can find you on the case.
My key what?
So it's 306.
Oh, I'm sorry.
894, so give me your piece of it. Is it 896? Is it 897?
Oh, I just have it printed out on
You
here.
got it. Okay.
Yeah, I don't
It doesn't show on yours where your piece
no,
of
it does not. I have the site. I don't
All right,
have
let me find what you're talking about. Go ahead.
So the Supreme Court held the detective's statements were not hearsay when used to show the interrogation technique and the effect on the defendant as listener, not to prove that the other witnesses' statements were true. As in Myrick, the truth of the embedded accusation is to the point. The point is that the effect of the information on the person who received it. Gant's claimed possession of the information and the conclusion she expressed in the post. So that's what it's used for, Your Honor. That's why I would say that it's not hearsay. But I think it comes in under OCGA section 24-8-8033. It can come in if the court says that it's hearsay, but there's an exception. And the exception would be then existing state of mind. It would be her then existing state of mind, which would be
Her being whom?
Ms. Gant.
Okay.
All right. A statement of then existing intent, plan, motive, design, mental feelings, or emotion may be admitted even if the defendant is unavailable. The exception does not permit statements of memory or belief to prove that the fact remembered or believed. And so the fact that she has made all these statements, it goes to her then existing state of mind about how she believed this investigation was going to turn out and how she intended to vote. The other thing, Your Honor, is OCGA section 24-8-801, parenthesis D2D, party opponent. The statement offered against a party by the party's agent,
Who is the party that you're referring to?
the party would be the city.
Okay.
So,
This is Ms. Gant's statement?
correct, Ms. Gant's statement, all right?
How would you find on her she's a party?
Well, she is an agent of the city. So therefore, because she's an agent of the city, it could be like an employee or something like that. I'm offering against the party opponent. And what it says is a statement offered against a party by the party's agent or employee about a matter within the scope of the relationship made during the relationship is not excluded as hearsay. And so that would be an alternative of argument that I would make.
Okay. I have never heard that.
Thank you.
We don't, I have one question, I think.
No, I've already moved on it. You had your opportunity to speak. Now, if I've made my decision, you can go over it.
Thank you.
That's something you want to put that record that you didn't know about.
Yeah, I'd like to question Ms. Thomas about this, if I could.
You'd like to report your response.
Yes.
Okay. You go ahead.
You have one for us.
Okay. I will allow you to report it. Go ahead.
Going right now? Cool. Ms. Thomas, that packet that you're looking at, did you print that out?
The second package?
Yes. Yes, ma'am.
No, I did not print it out.
Okay. When's the first time you've seen that?
The printed package
Yes, ma'am.
is small.
Okay. I have no further questions, Your Honor.
Mr. Kennedy.
There you go.
Let me just substantiate context for the record, Your Honor.
You'll do it again. I'll allow you to do it again. I'm Smith.
And I'm not gonna go through all of the statements, Ms. Thomas, but I wanna direct your attention to some of the statements. Can you go to page 3? And do you see a conversation or comments by Lakeisha Gant in response to a Jamel Parker or directed at a Jamel Parker?
I do.
Okay. And can you read that, please?
It says, I thank you for the compliment. I have witnessed with my own eyes and ears how many people have tried to help him, to include other mayors in our city council and our city manager. Everyone has tried. The one thing we can do now is let the investigators do their job.
I want to also refer you to I have this. Can you read that?
Jamel Parker and I, Jamel Parker.
Let me just make sure that I'm understanding the speaker. This is Ms. Gant speaking.
Yes,
Yeah.
speaking to,
So what the witness is reading is Ms. Gant's words.
correct.
Jamel Parker, and why exactly is that? Because we're doing our job in protecting the city, because we're doing what the charter requires us to do. Because if it was anywhere else, the punishment punishment would have been much worse. This isn't even a punishment, this is policy. This is to protect the city.
All right, I want to draw your attention.
David Ash, we all did. And I'm sorry, but some of these things are written in broken pieces. David Ash, we all did. And I have receipts on my attempts. We didn't strip the mayor of his duties. We temporarily restricted his perks, not his duties. For example, the mayor still presides over meetings. That is his duty. He still receives a stipend or monthly salary. Perks temporarily restricted are such as driving a city vehicle to an event is a perk. If the mayor is attending an event in his official capacity as mayor, he currently drives his own car, his own vehicle, keeps his mileage, and gets reimbursed.
Now, can you go to the next page? Can you read that?
Feel free to go onto my Facebook page and look at my posts. The mayor has been warned, trained, coached, advised, you name it, and I have receipts. I only put on example of receipts. I only put on examples of receipts down to where there are plenty. No one is trying to harm the mayor. Just how many chances would you like us to give him? Because I can count somewhere in the double digits. No one asks us how many times we have warned him, how much training he has received, how many times he's been allowed to correct his behavior. I can answer that, multiple, because we're all trying to cheer him on. This has got to stop. Everyone wants the pages cut off. Because everyone wants the pages cut off.
All right. Just a few more. All right.
And how people watch everything we do. Jayden knows exactly what I am talking about. He received warnings. Those text messages on Facebook pages are just a small example of the warnings. Feel free to read a sample of the text messages and warnings I have made on 2 separate posts. one to him and his grandmother. I put them on Facebook page and told them the reason why. I'm going to say it one last time. Jayden Williams is not a victim. The city of Stockbridge is. And anyone who wants to sweep serious allegations of misusing funds, abuse of power, sexual misconduct under the rug because he's so young and speaks so well, he is an enabler. So shame on anyone who enables. Right is right and wrong is wrong. Raquel Austin Jones. The mayor started with social media. It's a new form of getting communication out. There are no rules or regulations on how to get communication out. Times have changed. If the rules apply, they apply to all.
And is it fair to say, and I'm not gonna go through every one for sake of time, is it fair to say that there are other comments made by, and you can look through it, made by Ms. Gant, discussing, any investigation or situations going on with the mayor, or allegations, what I'm gonna say, discussing allegations going on with the mayor?
It is very fair to say it's almost like you trying him on social media.
Fair question.
Mr. Washington.
Yes, Ms. Thompson, I just have a couple questions for you. The last texts that you got from Councilwoman Gant, were they approximately July 21st, 22nd?
The personal text messages, yes.
Okay. And to speak specifically about that packet that you received, or that packet that you were talking about, when did you read all of that stuff?
When did I read all of this?
Yes.
I didn't read it all, sir.
Okay.
But I am very involved in social media. I do read the comments about Ms. Gann and other people in reference to how things are trending on this case.
Okay. And you didn't print that out?
I did not print out that package.
Okay. And when was the first time you seen that package?
This complete package today.
I have no further questions.
Mr. Candace, I thought you have any additional questions?
Just briefly, what's the date on what's the timestamp or the date on the Facebook post?
The one here says August the 7th. And filtering through the pages, they're all saying August the 7th.
Thank you, I have no further questions.
Let me ask a question, Ms. Thomas. The Facebook messages, did you see them when they were posted to the computer? Or have you only seen them as part of this exhibit?
I have seen some of them on the computer, but not all of these.
The ones that you read specifically into the record, did you see those on the computer or did you just see those as part of this package?
Okay, it would be hard for me to distinguish between the two, because when I'm on the system, on the computer, I'm scrolling, reading, scrolling. And I'm trying to think specifically which ones I saw would be difficult for me. I can tell you that I've seen the messages, but I cannot tell you if the ones I read today specifically in what frame time that I saw.
Are you able to testify whether you saw the messages in front of you before today, or was today the first time that you saw
messages, some of these messages on the computer. And I saw more of these messages today. Some more in the package than on the computer, ma'am.
Does that cause either party to have any additional questions for this witness?
Not from the plaintiff's side.
Mr. Washington?
No, it's not, no.
This witness can be excused then?
Yes, Your Honor.
Pardon, excuse if you'll watch your step as you get down. Call your next witness.
Plaintiff's rest, Your Honor,
Can I
and
have those please?
Ms. Thomas remained since she's been, remained in courtroom since she's been.
Thank you. You can remain in the courtroom since you've been excused from testifying. Let me see, I've got P1, P2, P3. P2 is 4 pages for the record. I'm gonna staple those together. And then I have P3. The plaintiff having arrested, Mr. Washington, do you have any witnesses you'd like to call, sir?
Yes, and what, yes, I'm going to call Councilwoman Gann, I just want to make sure I perfected the record on my objection, Your Honor.
Go ahead.
I think further with the question to be established, that this shows that a couple things. One is that well, two things. The witness was not a participant in the exchange. There's no personal knowledge of the office here to be able to authenticate them. And under Rule 801D2, it applies only after the proponent proves that the statement is in fact in the party's statement is an adopted statement or an authorized statement. The disputed post cannot establish that correctly by itself. And under OCGA 24-9-91, that limitation also applies because the limitations that they're attempting to get this in under has to be a present sense impression, which clearly was not established by the conversations that we had with her. And so that was how I wanted to make sure I protected it. I'm ready to call Councilwoman Gann.
Okay, and so based on the conversations that I've had with Ms. Thomas, I will rescind the admission of P3. The witness did sufficiently lay the foundation that the Facebook page belonged to the council member and that the messages may have come from the council member, but she failed under prom that sufficiently established that she saw these messages and these messages were posted at some point in time from Ms. Gann that was outside of her review of the exhibit for her testimony this morning. Call your first witness.
Thank you. I'm grateful. Councilwoman Gann. Will I swear the witness in?
I'll swear to have done all the others.
Thank you.
Your Honor, could I get,
Somebody grab the council person?
Yeah, everyone now.
Go ahead, Mr. Chairman.
could I get the exhibit?
Oh, no, you've offered it, so it stays in evidence.
Oh, okay, I'm just saying, I'm gonna try to get it in.
Oh, cool.
Yeah.
But you wanna use it again, but
Yeah, yeah.
make sure it stays with my vote.
Right.
Okay? All right, here you go. Watch your step as you come up. You'll raise your right hand to the oath. Once you put your back down, you solemnly swear and affirm the testimony about the establishment, the whole truth, and nothing but the truth, so help you God.
I do.
You can have a seat. Once you sit down and you're comfortable, if you're alone the entire night, count to 10. Okay. State your name for the record.
Lanisha Gant.
Witnesses with you, Mr. Washington.
Thank you so much, Your Honor. Good morning, Ms. Gann. Good early afternoon, Ms. Gann. How are you?
Good afternoon.
Good afternoon. I want to just ask you a couple of questions. We're here about emergency jail. And how long have you been on Stockbridge City Council?
For 13 years,
Okay. And what district do you represent?
District 1.
Okay. And as a council member, what are your duties when a constituent brings you a complaint about the conduct of the city official?
My duties are to give them the process and procedures of what took place, and to notify the proper authorities of which we need to, whoever we need to notify, or do whatever we have to do based off the charter.
Okay. Are you able to perform those duties without knowing what the complaints are?
Yes,
Okay. No, I'm sorry. Do you have to know what the complaints are to perform your duties?
Yes.
Okay. And in the ordinary course of serving your district, you communicate with residents and other council members about city business.
Yes.
And there have been some communications which we're going to get into that Mr. Kenner has posted, and I want to walk you through those that are in evidence.
Okay.
And I want to first take a step back and ask you this. There allegedly there's some Facebook posts that you've been putting up which question your impartiality to sit as a member of the tribunal in the city of Stockbridge. Are you aware of that?
I'm aware of that.
Okay. And what would you like for us to know about these posts? And I'm going to go through them one by one.
Sure. We have been beating up the city of Stockbridge over and over again. We had we chose a Friday at 6 o'clock p.m. To have a meeting in regards to some information we received. And what I want the court to know is that when I responded to those, when I posted, it was in response not for the purpose of bias, not for the purpose of trying to make a decision on the case, but I always talk to the constituents in layman terms. And what I do, I just explain, no one's trying to hurt our mayor. This is not something that we're not out to set him up. I received calls. I get stopped everywhere I go. I was just outside. Nobody know why, they don't know what's going on in here, just outside. And the same thing, I can't go anywhere without someone saying something.
That's fine, if they're outside the courtroom.
Outside the courtroom right now, just walking by, someone says, oh, hey, and I'm sorry what's going on, or they're talking, someone wants to express their concerns.
And this is a member of the public, not myself.
No, members of the public, yes. And what I'm saying to you on that is that no one's out to hurt Jayden.
Okay.
And I hate that this is on his birthday. I hate to have that, but he knows I'm not out to hurt him. And we have a job to do. When I received the information that the entire council received, I have a duty. And I did what I had to do. But that does not, and I've told everybody, please just wait. Wait until this investigation is over. Let's sort it out. Wait until it's over, because there's some embarrassing things or potential embarrassing things. I just didn't want to make a circus out of what this has become. And
let me stop you right there if I can. Given what has happened, are you able to sit as an unbiased person if you were sitting to make a determination about evidence that you would get back?
yes,
Okay. And I want to ask this question.
I'm an officer of the law. I'm an attorney. I know exactly what I'm doing here. And I have been what's more upsetting than anything, I've known Commissioner Thomas for a very long time now, and I have a personal relationship. Anything I've done is to protect Jayden.
Okay, so I had some questions prepared. However, I'm going to ask this question out of sequence, and here's what it is. What were the text messages about that you were trying to protect the city of Stockbridge from?
I'm sorry, what are you talking about? The text messages?
The text messages that you sent to Ms. Thomas, and she was talking about, she specifically said about saving her grandson from something and all this stuff. What was it referencing?
It was referencing why we had to
have the investigator. Why we voted for the investigation? We had information that Jayden had sexual misconduct with an 11th grader. And the reason his contact with that 11th grader in high school, a local high school male, 11th grade male, was due to the fact that he had a mentorship program, some kind of mayor mentorship or ambassador program that the young male was a part of for the city of Stockbridge. And so to prevent